Good afternoon and welcome to our afternoon panel of the Zoom Federalist Society Convention. I want to welcome our wonderful speakers. As anyone attending probably knows, this is on labor and employment law, and we have some agency leaders that are going to discuss labor policy. I want to give out the CLE password first, which is WCV12. Again, WCV12. So you have the password now. Hopefully I will give it out at the end. The first thing I'm going to do is introduce our speakers, and then I'm going to turn it over to them. Our first speaker is Cheryl Marie Stanton. Ms. Stanton was nominated by President Donald J. Trump to serve as the administrator of the department's Wage and Hour Division and the U.S. Senate confirmed Ms. Stanton's nomination on April 10, 2019. She was sworn in as WHD's administrator by the U.S. Secretary of Labor, Alex Acosta, on April 29, 2019. She brings a wealth of experience to WHD, most recently having served as executive director of the South Carolina Department of Employment and Workforce. Under her leadership, South Carolina's jobless rate dropped to its lowest point in the last 50 years. During that time period, South Carolina's workforce system helped place over 500,000 South Carolinians into jobs. Stanton also partnered with her colleague at the Department of Corrections to create a job entry program for ex-offenders, receiving national accolades. She also oversaw two major information technology modernization projects that improved customer service and increased efficiencies for employees. She served as the White House's principal liaison to the DOL under President George W. Bush. She's a graduate of Williams College and earned her law degree from the University of Chicago Law School. Our second speaker will be Mr. Peter B. Robb. He's the general counsel of the NLRB. Mr. Robb was sworn in as general counsel of the National Labor Relations Board on November 17, 2017 for a 4-year term. Mr. Robb was nominated by President Donald J. Trump in September 2017 and was confirmed by the U.S. Senate on November 8, 2017. Mr. Robb was previously a director at the Northern New England law firm Downs, Racklin, and Martin. He joined DRM as a director in 1995. He chaired the firm's labor and employment practice group from 2000 to 2009. And served as deputy managing partner from 2009 to 2012. He has also served on the American Bar Association's Practice and Procedures Committee for the National Labor Relations Board. He served as JD from the University of Maryland Law School and as Bachelor of Arts from Georgetown University. And last but definitely not least is Cheryl Gustafson, who's the general counsel of the Equal Employment Opportunity Commission. After practicing employment law for 28 years, she was nominated to serve as general counsel in 2018 and was confirmed by the United States Senate on August 1st, 2019. She is the first woman to serve as general counsel at the EEOC. Before joining the EEOC, Ms. Gustafson advised and represented both employees and employers in employment-related legal matters as a solo practitioner in Virginia, Maryland, and the District of Columbia. She represented Peggy Young in a famous pregnancy discrimination complaint against the United Parcel Service that ultimately ended up in the United States Supreme Court's seminal 6-3 holding under the Pregnancy Discrimination Act that an employer must provide to pregnant employees the same accommodations it provides to other employees with similar restrictions. She began her legal career in labor and employment law with the Labor and Employment Law Group at Jones Day in Washington, D.C., where she practiced for 4 years. She earned her JD from Georgetown University Law Center in 1991. And now I turn it over first to Ms. Stanton, and she will turn it over thereafter. Ms. Stanton.
Thank you, Judge, and thank you to the Federalist Society for having us today to talk about labor policy. As many of you know, this is an area near and dear to my heart. Not only did I practice as an employment lawyer, but many of you have heard me talk about my dad was an employment lawyer before me, and so we had a lot of conversations about employment law at the dinner table while I was growing up. I thought that's what dinner conversation always was. So coming into this role, it was with a lot of excitement, but I knew there was a lot of work to do. And when we arrived in April of 2019, there was a little bit of a regulatory agenda already in place that we needed to follow through on. As many of you know, there is the overtime story for the Wage and Hour Division, which is a tortured one in terms of the regulation. As you know, under the Fair Labor Standards Act, there's something called the standard salary level. And if an individual is making less than the salary level that is established by regulation, the assumption is that that individual is doing duties such that they are entitled to overtime or time and a half of their wages for hours worked over 40 in a work week. That standard wage rate was started in the 40s, and in 2004, a new level was set at $455 a week. And it was done in a very methodical way. The Wage and Hour Division looked at the 20th percentile of salaried retail as well as Southern Census salaried workers and set the standard at that level. But then that level sat for 15 years. In 2016, there was an attempt to raise that, but the raise was done in a very jarring way, going to the 40th percentile. And that resulted in a lawsuit that many people on this webinar know about. Ultimately, when we came in, we reissued an NPRM that went ahead and reverted to the methodology of 2004 that had stood the test of time for 15 years. And last September, we did finalize that rule to go into effect January 1st of this past year, resetting it to the 20th percentile for for salaried retail and South Census. And that has not been challenged. So we've established now a methodology that stands the test of time. Multiple other regulations that we have done in the last year is regular rate. I mentioned you get time and a half over hours worked over 40, but time and a half of what? Sometimes it is just the hourly rate you were paid, but other payments can get put into that. We did do that we updated that regulation from the mid-20th century. Mid-century architecture is beautiful, but mid-century regulations probably need some work. And that regulation had not been done by notice and comment. So we did it by notice and comment and identified modern perks in the workplace and whether they needed to go into regular rate or not. Similarly, the joint employment rule had not been promulgated through notice and comment and was decades old. We issued a new joint employment rule in January, which, as you know, the state of New York has challenged and we have appealed the ruling criticizing that rule. In addition, though, last year we had a couple of curveballs. 2020 is nothing if not the year of adapting and dealing with the unexpected. And for the first time, there was a federal law put into place to impose a paid leave requirement widespread on the private industry, and that is for companies with less than 500. Many of you know what it takes to write a rule. We had to write a rule in 12 days to stand up that law and that new payment program that President Trump signed into law, which we did, and then implemented a program that we've seen over 3,000 cases closed since April 1st. We've done over 2,500 outreach calls or outreach events and taken over 350,000 calls. And by that, I mean answered the call, not returned a voicemail. We also had USMCA, and you may say, why is the Labor Department dealing with a trade agreement? Well, the United States, Mexican, Canada agreement for the first time implements certain wage requirements, particularly for those in the automotive industry. We can get into more detail on that later, but it is the Wage and Hour Division for the first time in history that will have responsibility for enforcing part of a trade agreement. And this was really crucial to ensure that certain payments were made to American workers vis-a-vis Mexican, level the playing field vis-a-vis Mexican and Canadian workers in this space. We finalized the fluctuating work week rule, as many of you know, in the spring, and are in the midst of finalizing the tips and independent contractor rule. But another very important thing that we have done in policy space is we reinstituted the opinion letter process. As many of you know, the 1947 Portal to Portal Act gave the Wage and Hour Division unique authority to issue sub-regulatory guidance in the form of opinion letters, which the previous administration had shut off. We turned that back on and have issued nearly 70 opinion letters in this administration alone. But I think that needs to be viewed in the backdrop of something very important, and that is the two, and I hope we talk more about this in a bit, the two major executive orders that President Trump issued last October. One was regarding promoting the rule of law through improved guidance documents, and the other one was promoting the rule of law through transparency and fairness in civil, administrative enforcement, and adjudication. Those of you who heard Secretary Scalia speak last year at the convention heard his view that it is very important that employers are given fair notice as to the responsibility and employees have fair notice of what they're entitled to. We are not interested in creating policy through enforcement, but rather through fair notice to the regulated community. To that end, after those executive orders came into place, we spent weeks and months working our way through our opinion letters back until the 1960s, and I'm talking about over 5,000 opinion letters, to identify those that were still good law, still good policy, and were guidance that the regulated community could rely upon. We then took the further step of putting them onto a searchable database. I am so old that I remember going to the library, going through the binders to try and find opinion letters on a particular topic. Now you can do it by going to our database, which is at www.dol.gov/guidance. We can talk about specific policy, and I hope we do as we move forward, but I think it's important to understand that the real goal of this Department of Labor overall, and you will hear Secretary Scalia again tomorrow afternoon, I think, speak to this, has been transparency, accountability, but also opportunity. And I think one of the things, there is no greater measure. All you have to do are look at the results. We are looking at an administration that has ensured that the lowest quintile of wage earners have had the greatest net worth throughout the last 4 years. The highest wage growth for women, some of the lowest unemployment rates for African Americans, Asian Americans, and Hispanic Americans. And it's through not only the policy choices and policy put into place through the Labor Department, but also through the transparency and fair notice that we have given the regulated community so they know the rules of the road when they're in the front end and not when they're being punished. I know we have a lot more to talk about with each of these policy decisions and what's going on at the Department of Labor, but now I'd love to turn it over to a wonderful partner in the labor space, and that is Mr. Robb at the NLRB.
Thank you, Cheryl. I'd also like to thank the Federalist Society for inviting me. It's a privilege to speak here. I also would like to thank all of those behind the scenes who put this together on the technical end. It always amazes me how well these work. I would like to point out at the outset, if you hear a very loud noise buzzing behind you, it's because I'm coming to you live from the west coast of Florida, and we're periodically getting blasted with updates on Hurricane Ada. If I disappear entirely, then you may be able to say that you were present at the last speech given by the General Counsel. But I hope none of that interference happens. So this week, I will complete my 3rd year of my 4-year term. Since I haven't spoken to this group before, I thought I would discuss what, since my return to the NLRB, have been the major themes and concerns. When I came back to the agency, I found there was much to do. I've been fortunate to have been able to work with the assistance of 3 fine board chairs, Phil Miscamera, Marvin Kaplan, and John Ring, 2 deputy general counsels, John Kyle and Alice Stock, special advisor to the General Counsel, Dolores Boda, and the many fine career staff at the NLRB. Without this support, I could not have achieved anything. I've summarized our work in 3 themes: substantive law, administrative challenges, and infrastructure improvements. But first, I'd like to talk a little bit about the role of the General Counsel at the NLRB. I think it's important to understand my role. As General Counsel, I have dual role in prosecuting cases under the National Labor Relations Act and legal proceedings at the administrative, board, and the federal, district, appellate, and Supreme Court levels, as well as overseeing the operations of approximately 90% of the agency. The General Counsel is responsible for prosecuting unfair labor practice charges brought before the agency at about 17 to 20,000 per year in recent years. The processing and representation petitions filed with our regional offices, for enforcing the board's orders, and for supervising the operations of our regional and satellite offices throughout the nation, as well as our staff at headquarters, who are responsible for case handling, operational, administrative, financial, security, facilities, technology, and personnel functions. And no, I do not read every complaint, brief, or investigative report, but I read enough that my lens prescription has changed several times this year, and not in a good way. So let me start with the case decisions. In one of my first GC memoranda, 18-2, I announced that I would review issues where precedent had been changed recently to determine whether the board should revisit the issue. And I did. And the board did, by returning to well-established precedent in many cases. But that is predominantly their story. And as I look out the window opposite, I can clearly see that the sky has not fallen, as some had predicted, but the case law has changed. I have advocated personally for the expansion of protections of employees' rights under the Act. In GC 1901, I instructed the regions to issue complaint absent settlement for a union's breach of the duty of fair representation to employees when they were forgetting to file grievances repeatedly, failing to apprise employees of the status of grievances, and consistently failing to communicate with employees. I advocated that these should not be dismissed as mere negligence because of the severe impact on employees. In GC 1906, I instructed the regions in the investigation of the improper withholding of dues in Beck cases, challenging the chargeability of dues expenses for political and other non-representational purposes. I sought to protect employees from violence, racial harassment, and other forms of discrimination that occurred in the course of protecting concerted or union activities. The board substantially did that in General Motors case, 369 NLRB number 127, just this year. So we've done a lot with respect to changing the law at the board, most of it going back to well-established principles that have been in existence for decades. I also focused on agency operations. When I came on board, I found that the time to process cases had grown, creating a large backlog of unprocessed cases. I was concerned about the time it was taking, driven by a feeling that resolution of labor cases delayed is labor peace denied. I proceeded to enhance the timeliness of cases. In the fall of 2018, Chairman Ring and I issued a new strategic plan to reduce case processing time. I was very proud of the regions in the agency which have met the challenge and have reduced case processing time. At the same time, by every measure, the quality of case processing has been maintained, and some regions have reported that it has improved because investigative cases are being done earlier when the dispute and the evidence is fresher. The goal was, using fiscal year 2018, which began on September 1, 2017, using that as a baseline for processing time to reduce, and the goal was to reduce the case processing time by 20% over 4 years. I am pleased to report that in just 2 of the 4-year strategic plan, we achieved most of those goals. The regional offices continue to far exceed expectations and have reduced the average case processing time from the filing of an unfair labor practice charge to disposition by 18%. And that's through fiscal year 2020. And that's also despite the pandemic. The regions overall reduced the time from filing an unfair labor practice charge to disposition from an average of 90 days in fiscal year 2018 to an average of 73 days in fiscal year 2020, and reduced the time from informal settlement to final disposition of a ULP from 172 to 136 average days, decrease of 21%. That's important because that's what affects employees directly. We settle most of our cases, about 96% of the merit cases, and in those, getting the remedies to the employees quicker is a paramount concern to me. Finally, I want to talk a little bit about rebuilding the infrastructure. When I came on board, the agency had not been expending funds on technology in any significant manner for some time. Therefore, I deemed it a top priority, and together with Chairman Ring, we moved the agency forward. In the last 2 years alone, we have spent over $50 million to improve our technology, not maintain it, but to improve it. We have increased the capacity of our cloud significantly. We moved to the cloud from our own servers, which did increase our capacity. We bought laptops, which for people that were woefully out of date. We updated numerous programs. We, during the pandemic, moved to Zoom, and we're doing hearings for unfair labor practices and representation cases remotely through the Zoom technology. And when the board went to Zoom in a matter of weeks, we trained hundreds of our attorneys in how to present unfair labor practice cases at a Zoom hearing. We improved NextGen. We speeded up the processing time. And overall, I would say that we now probably rival any of the private sector attorneys who, in big law firms, who appear before us in terms of technology, speed, accuracy, and in terms of capacity. Now, we also moved towards an electronic filing. I issued 20-01 GC memo dealing with electronic filing of documents, GC 2003 dealing with guidance on electronic issuance of deferral of cases, 20-5 guidance on electronic issuance of complaints and compliance. In essence, what we were doing was we were moving to a paperless operation, and now all of our case files are paperless. All those who appear before us in almost every aspect they're required to use electronic communication unless they don't have such. And finally, a few weeks ago, we announced an update and enhancement of the agency's public website that includes several new features that will improve the user experience and make the website easier to navigate. We'll also have, for the first time, included many pages of content on our website in Spanish. I consider this a significant improvement and a step in the right direction, but only the first step. We'll continue to work on that. And finally, I would be remiss if I didn't mention something about the operation of the agency during the COVID pandemic. The agency, except for a couple of instances where there was temporary closure in order to deep clean an office that had been directly exposed to someone who had COVID, we remained open constantly. We worked around every issue and problem that came up. We were able to continue to do our work and process our cases on time. We worked remotely to make sure that elections were conducted and counts were made. We even had some of our people counting mail ballots over video through Zoom. We're quite proficient at that. And my priority during this time, of course, was to keep our employees safe while at the same time serving the public. And I think the employees have done a terrific job of that and deserve everyone's sincere appreciation. So we have been busy. And I'll just close by saying that it's been a great honor to serve as the General Counsel of the National Labor Relations Board. As I said before, I do have another year left. And with that, I will turn it over to Sharon.
Thank you, Peter. And thank you for inviting me to speak. I'm Sharon Gustafson. I'm speaking today from my perspective as General Counsel of the EEOC, the person responsible for conducting the agency's employment discrimination litigation and for ensuring compliance with the statutes we enforce. I am not speaking on behalf of the Commission, which is the agency's policy-setting body. For context, I arrived at the EEOC in August 2019, 3 months after Chair Janet Dillon arrived. 3 of the agency's current commissioners arrived in the last month, and we now have, for the first time in the current administration, a full complement of 5 commissioners. The primary mission of the EEOC is to prevent and remedy illegal employment discrimination, and we've been doing that good work. Despite COVID delays, in fiscal year 2020, the agency obtained $106 million in relief, the largest amount recovered through the Commission's litigation program in the past 16 years. And the Commission experienced a 96% success rate for all resolutions, which is the highest success rate on record. Approximately 70 to 90,000 charges of discrimination are filed at the EEOC each year. Many, but not all, are meritorious. In my own 3 decades of employment litigation, discerning which stories merit a federal lawsuit has been an important part of my job. This was easier when I personally interviewed charging parties than it is now when I have access to only their written stories. Now I'm responsible for deciding which stories merit a lawsuit brought by the EEOC. Lest anyone think that all American employers have learned the lessons of non-discrimination so that the work of the EEOC is done, I share this story. A few months ago, I turned down for litigation a sexual harassment claim where a male employee alleged that his male employer, the owner of the 100-employee business, had, among other things, touched the employee inappropriately. When I declined to authorize litigation of the claim, I noted that before coming to the EEOC, the employee had first complained to the police, who had called in the employer for questioning. I suggested that I may reconsider my decision if I could review the videotape of the police interview with the employer. When the EEOC attorneys later sent me the police videotape, I saw this employer defend himself by saying that he would never touch an employee in the manner described. He said that he was a good employer, even though he would never employ Blacks, Mexicans, or homosexuals. He asked the police to tell him which of his employees had complained so he could kick his butt on the way out the door. I reversed my decision about not litigating that case. These are not microaggressions we are litigating. No, the EEOC's work is not yet done. In the last year, the EEOC's lawsuits included claims on behalf of female tunnel project workers who alleged sexual harassment by their male site superintendent and co-workers, a railroad employee with a brain tumor who alleged he was discharged after being denied a disability accommodation, older workers at a NASA research contractor who alleged they were disproportionately selected for layoffs while their recruited replacements averaged age 25, EMT who alleged her employer retaliated against her for reporting her white fellow EMT engaging in racially offensive conduct towards her, female applicants at a grocery distribution center who alleged they were subjected to a physical abilities test that was not job related and that denied women employment opportunities, a gay sales consultant who was subjected to a hostile work environment based in part on sexual orientation, 2 grocery store workers who were terminated when they requested as a religious accommodation that they not be required to wear LGBTQ pride emblems on their aprons. And the EEOC appealed a case on behalf of a pregnant Mexican property manager who alleged she was fired because of her pregnancy and her national origin. In the last year, the EEOC cooperated with the Department of Justice Civil Rights Division on several briefs in the US Supreme Court and at several circuit courts, as well as at a state Supreme Court. In Patterson v. Walgreen, we asked the court to revisit Hardison's de minimis undue hardship standard for religious accommodations. In Peterson v. Linear Controls, we asked the court to decide whether Title VII prohibits discriminatory working conditions or only discrimination in ultimate employment decisions. We joined forces with DOJ in Our Lady of Guadalupe v. Morrissey-Baru, in which the US Supreme Court further clarified the scope of the ministerial exception, which is grounded in the First Amendment's protection of a religious organization's right to be free from government interference in selecting those who will personify its belief, shape its faith and mission, or minister to the faithful. The Supreme Court, agreeing with arguments raised at a brief signed by DOJ and EEOC, explained that the ministerial exception bars discrimination claims by employees who play certain key roles or who perform vital religious duties at the core of the mission of the religious institution. EEOC again joined DOJ in an appeal in Payne Elliott v. Roman Catholic Archdiocese of Indianapolis in the Indiana Supreme Court, which presents a similar issue regarding a Catholic high school teacher. The reason the EEOC joined DOJ Civil Rights in vindicating the ministerial exception on behalf of employers is that the EEOC has an interest in the courts getting all aspects of employment discrimination right, whether getting it right helps the employee or whether getting it right helps the employer. Religious liberty has been a high priority for the current administration, where everyone I have spoken with has been unequivocally supportive of religious liberty for all. Title VII protects employees from discrimination not only on the basis of their religious beliefs, but also on the basis of their religious observance or practice. Employees are protected when their religion tells them that they must do something. For example, wear certain clothing or a beard, or observe the Sabbath, or when their religious conscience tells them they must not do something, such as take oaths, celebrate holidays, participate in abortion, dispense birth control, use technology, celebrate homosexuality, participate in a Bible study or prayer, and so on. Title VII does not just protect popular or majority religions, or those religions that an employer agrees with, or at least understands. Title VII protects all religious beliefs, observances, and practices. This is America. We get pluralism. We do that here. And as the name of the Equal Employment Opportunity Commission suggests, we do it equally. I have established a religious discrimination work group to look more closely at the full span of religious discrimination claims being filed so that we can better understand the various forms of workplace religious discrimination and improve our response to it. We have reviewed hundreds of recent religious accommodation claims and initiated tracking within our agency of the 4 broad categories of those claims: appearance, observance, expression, and forced participation. We have trained our investigators in spotting and classifying religious accommodation claims so that they can be handled more appropriately. The majority of religious discrimination cases that the EEOC has filed in the past have involved clothing and grooming claims brought on behalf of Muslims, Pentecostals, and Rastafarians, observance, including of the Sabbath, holy days, and prayer breaks, brought on behalf of Seventh-day Adventists, Jehovah's Witnesses, Jews, and Muslims, and forced participation claims, often flu vaccination claims, brought mainly on behalf of members of various Christian denominations. In the grocery store case I mentioned a bit earlier, in which 2 employees declined to wear aprons with LGBTQ pride symbols in violation of their sincerely held religious beliefs, rather than granting the employees' requests to provide their own aprons or to cover the logo with a name tag, the employer terminated those 2 employees. Since Bostock, we know that Title VII protects employees from discrimination based on sexual orientation or transgender status. But at the same time, Title VII protects employees from discrimination based on their religious beliefs that prohibit them from approving of homosexual acts or gender reassignment. The Office of General Counsel has participated with the EEOC's Office of Legal Counsel and Commissioners on a new draft of religion guidance, which is very much needed. I thank Chair Dillon for leading this effort. The existing guidance was last updated in 2008, before at least 3 key Supreme Court discrimination cases implicating religion were decided: Hosanna Tabor in 2012, Abercrombie and Fitch in 2015, and Our Lady of Guadalupe v. Morrissey Beru earlier this year. 2 days ago, the Commission held a public meeting and voted to approve an updated draft of its religious discrimination guidance. The religion guidance is not binding law. It is a chapter of the EEOC's compliance manual that reviews the law and helps both EEOC investigators and the public when considering these issues. The guidance will be reviewed by OMB and then published for public comment. Anyone interested in the topic of religious discrimination in employment is strongly encouraged to review the guidance and to make comments on how the guidance can be improved or strengthened. I expect to see litigation and clarification of the law, especially at the intersection of sex discrimination and religion discrimination. The EEOC's mission is to protect all employees whom our statutes were meant to protect, and the Commission has been diligent about enforcing all of our statutes, even where the various protections may sometimes come in tension with each other. The law and American pluralism require no less. Thank you. And now, back to Judge Thapar.
Thank you all very much for great opening talks. I guess I'll ask the first question and then we'll open it up. And since Sharon just finished, I'll start with Cheryl and Peter to give her a break and use what she said and ask, how have you and your agencies approached religious liberty issues over the past few years? Cheryl or Peter, you want to go first?
I'll go first. We don't have a lot of cases dealing with religious liberty because the National Labor Relations Act doesn't protect the right of religious freedom per se, but it has come up a little bit tangentially. One is an area of defining institutions that should be exempt from the act because of their religious mission. And the current board has issued a decision on that aspect of it, broadening the protection for religious institutions to allow them to require employees to refrain from certain types of activity that otherwise would be protected. But other than that, we don't have a lot with respect to religious liberty.
Thank you, Judge. In the context that it comes up in the wage and hour space the most frequently is with respect to the issue of what is an intern or a volunteer. And this ties nicely into today. I am remiss in not saying a very happy Veterans Day to all of our veterans on the call, as well as to acknowledge that over 30% of our wage and hour staff are actually veterans themselves. So after they have served our country, they come and serve the American worker in their own wonderful way. But one of the things that happened last year around this time was we issued a very important opinion letter regarding what is a volunteer and intern. As many of you may know, the Department of Defense has a program for transitioning veterans that allows them in their last 6 months of military service to work in civilian jobs, be paid their military pay, but allows them to get some experience, civilian experience, to make the transition easier. There was a lot of confusion about whether or not these were volunteers or interns with respect to the private sector companies that they were working for. And many companies were reluctant to use this program because of the fact that those employees could be deemed as having two employers, and the employer would be responsible for additional pay on top of the military pay. We went through last year the parameters of what it takes to be an intern/volunteer and made it clear that those individuals are employed by the Department of Defense, they're paid their military pay, and therefore are employees of that organization, which has opened that program for, I know it's a very important issue for Congresswoman Stefanik herself. Those principles apply in the religious context with respect to the Fair Labor Standards Act. But that's just a wage and hour itself. I would be remiss in not broadening it to the Department of Labor as a whole. We have a faith-based office that is very robust and very active in the faith-based community to ensure religious liberties. And recently our office, which is a sister agency, so I don't want to take credit for this, our Office of Federal Contract Compliance Programs, see, I have to remember the acronym because it doesn't roll off my tongue, recently put into what we call ROCUS, a final rule on explaining the religious exemption under Executive Order 11246. So there's a lot of focus in the department, even in areas, in the federal programs area where religious exemptions are front and foremost, but even in areas like the wage and hour where there's not a specific necessarily religious hook, we're always conscious of how some of our opinion letters and others may impact the religious community.
Thank you. And Sharon, what religious liberty issues do you see on the horizon, just to play off what you said in your talk? Do you see any new or different issues that are coming up in things people should be aware of?
Well, first I want to say the EEOC, I don't want to suggest that the EEOC hasn't been bringing religious discrimination claims. They certainly have. About 4% of our charges are religious discrimination charges, and there are certain kinds that the EEOC has brought in large numbers. There have been many claims brought, Sabbath day observance claims or other sorts of observance claims, dress or clothing, appearance cases, beards, that sort of thing, even quite a few vaccine cases. We've seen quite a few of those. We have seen very few, if any, of some other sorts of religious discrimination that people have experienced. One is people who, because of their religious consciences, as I mentioned in the grocery store case I was talking about, cannot celebrate homosexuality. And they simply have to be permitted to refrain from saying things or appearing in ways that would show them celebrating this. I think we're going to see more of those kinds of cases. There's also situations with nurses, and I've heard several of these stories, nurses in hospitals who, because of their religious beliefs, cannot participate in elective abortions. And those are cases that I don't believe the EEOC has brought yet, but I think those cases are out there, and I imagine that they will come, and those are cases that should be brought in the future. And because of Bostock and how the law has been clarified recently related to that, I think that the topic of religion and sexuality will be an increasing number of cases.
Thank you very much. So now I'm going to open it up to the floor for questions. I want to remind you that we're only taking questions via Zoom. There's no way to ask questions of the speakers using other platforms. To ask a question, we ask that you use the raise hand button, which is in the lower middle of your screen. If you're a Zoom telephone participant, hit star 9. I will then call on you. When I do call on you, please unmute yourself and ask your question. I'll finally remind you that we have 3 wonderful speakers, and I expect them to speak, and I expect you to ask questions. That means whatever sentence you're speaking should end in a question mark. All right, and we will begin. Tammy McCutcheon, go ahead.
All right, I've unmuted. Is this working?
It is working.
All right, my question is, people will not be surprised, is for Cheryl. Cheryl, I want you to please assume that that we will have a President Biden and look a bit to the future. One of the things that I'm sure we're going to find is that any new administration is going to accuse the Department of Labor of not having been enforcing the law. And I'd like to have your perspectives on that, of enforcement under Democratic versus Republican administrations. And I think I'd also like to know, what do you think the future of your paid volunteer back wage program is going to be?
Thank you, Tammy, for that question. Let me start on the enforcement side. I'm not going to necessarily talk about others' philosophy about enforcement, but let me start with mine. I started at the beginning about dad, dinner table, conversations, workplace. And the one thing I always remember is his conversations about wage and hour investigators. And he was always happy when it was those investigators who showed up on his work site, sorry, Sharon and Peter, because they were always the most professional, the most educated in their area of law, and the most respectful of the process. And so some years later, when I started talking to him about this role, he laughed pretty hysterically about it, told me I was in over my head, and they would run circles around me. And so when I came in really trying to understand the civil law enforcement side of this agency and what it was doing. And one of the things I was, you have heard me say repeatedly, Tammy, disheartened to learn we had not hired an investigator in 3 years, and immediately sought to start rebuilding those ranks. I will give a plug not only to our agency, but our sister agency that handles hiring. We did onboard 175 investigators during the pandemic, and another 40 what we call technicians, who are those who think of them as paralegals to a lawyer. They're the paralegals to our investigators. And one of the things we talked about when I came in was getting back to basics. We did not want to be enforcing cases on the edges that allowed for us to create new law or new liability requirements. Instead, we went back to focusing on basic wage and hour and FMLA violations, not those things that we could go to a court and convince a judge to create some kind of new theory of how the law worked. In that area, we really got away from, we also started emphasizing getting back to low-paid workers. We wanted the most vulnerable, low-paid workers to be our clients, because those were the ones who were not unionized, who could not get easily to a high-powered plaintiff's law firm that brings these massive wage and hour collective actions and get millions of dollars in cases. They don't want the minimum wage workers because they can't get necessarily the $1 million payout. So we really got back to focusing on the most vulnerable of workers at minimum wage. And we've even started using data to analyze the outcomes of these. We've created some indexes to score our investigations to say, are we going for some of the severe cases? And severe cases are not defined by the amount of necessarily by the amount of back wages we recovered. We look at things like, was this a minimum wage employee? Were we getting the minimum wage and scoring it in such a way that we recognize and value that our clients are those who are the most at need? So, what I would say with respect to our enforcement during, the last 18 to 20 months has really been a focus on those who don't have other outlets. We don't need to go and do massive investigations in unionized workplaces all the time. They have recourse, but I realize they get big back wage cases, so everybody thinks it's fun and sexy to litigate. I want to help the mom who can't put the food on the table. I did a lot of pre-COVID visits to our offices, and to get the investigators to talk to me, I'd always make them go around the room and tell me an interesting case, something that they worked on that really got to them in the last year. And it was last year at this time in Orlando, an investigator said to me, I was really just so relieved when I got the second set of books so I could figure out how they were paying people, under the table. And I looked at them and I said, second set of books, that's crazy. And an investigator 2 seats over looked at me and said, that's nothing. Last year I had to get to the third set of books before I could figure out how the payment structure was working. I said 3 sets of books. If you can figure out how to do 3 sets of books, you can figure out regular rate, even as technical as it is. So there are real people out there cheating and cheating not only workers, but cheating their competitors and getting an unfair advantage and taking advantage. And so, the last 18 months, we've really started refocusing on those people who really cannot get at it another way. So I hope that focus on low-wage, vulnerable populations continues no matter who is at the Wage and Hour Division, because those are the people who need us the most. A quick word on paid. Those of you who don't know what that is, it's basically a voluntary compliance come forward program. Under the Fair Labor Standards Act, you cannot get a waiver from your employees for paying back wages that you missed under the FLSA unless a court blesses it or the Department of Labor. For years, employers who found mistakes in how they were paying were faced with a very tough choice. Do they own up to it and try and make it right and then face a massive collective action if the employees decide to go to a plaintiff's counsel instead of resolving it because they could never get a waiver for it, or just making the correction and moving forward? We said, raise your hand if you made a mistake, open your books, let us audit where you say you made the mistake. Tell us how you're going to make it right, and we will bless it. This is not a get out of jail free card. This is making sure that workers get paid the money that they were owed for this mistake. And it's a highly successful program. It doesn't take a lot of time. It hasn't been a big tool in our toolkit, but we end up recovering 10 times the back wages per investigator hour that we put into this. And so, this is just one more way that employees can be made whole, even when we haven't found that one particular employer that made a mistake. So again, enforcement, I love it. I will tell you that 18 months into this job, everything my father ever said about wage and hour investigators and technicians and support staff, it's 100% true. I've never seen a finer, more professional group of people, and I'm very proud to be part of them.
Thank you. Shalom Stone, you're next. Please unmute and ask your question.
Can you hear me? Okay.
Yes, perfect.
Thank you. So I was wondering whether the agency has considered whether certain kinds of diversity training might be creating a hostile work environment, and whether there's a role for guidance on that kind of diversity training or sensitivity training that might create that kind of risk.
This is Sharon Gustafson. Is that a question for me at the EEOC or for someone else?
So you please.
Okay, I'm happy to answer that. Diversity and sensitivity and inclusion are very good things. They're good goals where employers want to do that and they can do it. It's fine and to do that, but it is very important for employers to remember as they do this, that what the law requires, what Title VII requires, is not diversity. It is non-discrimination. So it is very important that as employers try to do their own diversity program that they're interested in, that they not accidentally fall into discriminating against employees on some protected basis. And I do think that sometimes this desire for diversity and inclusion and sensitivity training does end up discriminating against people, perhaps accidentally, perhaps it's well motivated, but it accidentally ends up discriminating against people other than the people that it's trying to protect by telling others there's something wrong with you, you're racist or you're sexist or something of that nature that could be creating a hostile work environment for people that they don't intend to be creating one for. So I think it's very important to be careful about that. And I do think that that's something that the EEOC should look at. But of course, our enforcement is based on charges. So we will only do that to the extent that those charges are coming in.
I'll also, although it's a little outside of the wage and hour space, but recently the president did issue an executive order for federal contractors to, I'll just say at a high level, be more cautious about how those trainings are issued to ensure they're closer to what Sharon's describing versus other avenues. And if you're really interested in this area, I would direct you to the OFCCP website, because I believe they have an open request for information out for federal contractors to share their diversity and inclusion training, and for workers to do the same, so we can help, so that agency, or my sister agency, can help define that a little bit better. There's also a hotline. I don't have the number, but we can certainly get it for you, Shalom, on people who they can call in and share information about trainings vis-a-vis the EO. So I know that is a big focus of this administration, to make sure that that line is not crossed and the needle is thread properly.
Thank you both. I want to remind everyone that for CLE credit, the password, it should be on the top of your screen, which is WCV12, again, WCV12. I want to ask each of you, if you don't mind, what you think about the recent executive order establishing a Schedule F federal employee. Can one of you explain it? And then can all of you say what you think it means for employee protections, employee accountability, et cetera? Cheryl, you want to go first, since you're on my screen at least?
Essentially, so as you know, there are different types of federal employees. There are senior executive service, there's those on the GS scale, there's certain on different schedules. Earlier this year, we saw Schedule A employees, which are, I believe it's lawyers specifically, but that tool in the toolkit was expanded to allow for a more streamlined hiring of individuals who could directly help with the COVID fight. And so Schedule F is just an extension of that deals with those who are in policy positions. And I don't know all the parameters of it, but I do know at a high level, the concept behind it is a different form of federal employee that has a different kind of, it's in a different classification than the general federal employee. And this is for those who specifically do policy work. We all know that policy can change from administration to administration. And as one is doing policy, it is very important to have, if not someone who is aligned with your policy helping you enforce it, but of course those who are not against your policy. And so I think there was some focus on that in other spaces. You know, the Department of Labor, I've been very blessed in my agency, and I will say this very clearly, especially, I want to be very clear on this, and if it's reported differently, I will, you know, we'll circle back, but I want to be very clear that what I have found in my shop in the wage and hour division are, again, a group of professionals that have worked very closely with us on the policy that we have developed, discussed, implemented. There has been wonderful back and forth, devil's advocacy. It is not a situation where necessarily we all agree in every direction we go, but once a decision is made, we go there together. And it's been a very good relationship. So again, that's a tool in the toolkit that I have not explored, but I know was issued and created to help agencies and departments that needed it.
I don't have anything to add about Schedule F employees in particular. My understanding is the same as Cheryl's, but hearing her talk about her workforce over there at the Department of Labor makes me want to say the same thing about the career employees that I have met here at the EEOC. These employees they are smart, they are expert, they have so many years, so many of them have spent whole careers here, and they have so much expertise. They're very diligent in the work that they're doing. I've been just really impressed with the EEOC employees, especially the lawyers that I've worked with.
I want to remind the participants that if you have a question, use the raise hand button, and I am going to call on Peter. Did you have anything you wanted to add before I call on the next questioner?
Well, I'll just add briefly that I agree generally, of course, with the description of the executive order, but I wanted to say that it didn't necessarily surprise me because although I had nothing to do with that executive order, periodically in the last 4 years, we've seen some career positions in the government, people in career positions, claiming that they have independent ability to interpret and apply policy. So the issue certainly has come up in various places. And of course, generally speaking, it's the president, the executive branch that determines policy. So currently, like other agencies, we're simply looking into it. That's all I have to add.
Okay, thank you. I'll call on John C. John, you can go ahead. I'm sorry.
I think I'm on, correct?
You are.
Okay. This is addressed to General Counsel Robb. First of all, let me thank you. I think you've, in 35 years of doing NLRB work, I think you're the best general counsel we've had in these 35 years. I was wondering what you thought about Board Member McFerrin's suggestion or dissent or in the recent board decision, manual versus mail elections, where she indicated that even after COVID, the board should consider adopting purely mail elections. What's your opinion of that?
Well, first, I'd like to thank you for your comment and ask you if I could quote you on that if I need to someday. But with respect to Board Member McFerrin, I mean, I think her dissent was something that was, heartfelt and put forward honestly. My position on running manual elections is pretty well known. I've been out there now for a number of months. I did extensive research. We developed a series of protocols that suggested guidelines for running manual elections during the COVID era. We reviewed thousands of pages worth of medical expert evidence, talked to people, and I think we can run them safely. So there may be a difference of opinion there, but I think the board recently has clarified the situations in which it would be appropriate to run a mail ballot election rather than a manual election. Yesterday, I put out some further guidance, which is on our website for our regional directors. So I think that there are many circumstances, if not most, where we can run manual elections at this point. But again, ultimately, it's up to the discretion of the regional director.
Peter, while you're on the screen, can I ask you a question while we're waiting for other people to raise their hands, which is, how has the board addressed changes or reversals in policy and litigation strategies over the years? So I can give you an example. In the Duquesne case, as I understand it, the NLRB took the position that a Catholic school had an obligation to bargain with a union representing its adjunct faculty. That went to the DC Circuit. and Judge Griffith wrote an opinion for a divided panel where the board lost. You then changed your position, and in the Bethany College case, decided you didn't have jurisdiction over this, following in what your interpretation of Judge Griffith's opinion. So how do you decide? Maybe a court decision does it, or maybe an administrative change, but I think people wonder, how do these changes get made?
When a court disagrees with the board, as it did in that case, the case is remanded to the board. The board has to make a decision on whether to accept the remand, take it as a law of the case, challenge it perhaps in the Supreme Court, or if the court allows, revisit its decision and reinterpret the law, taking into account the court's opinion. I don't think there's been any change in how the board approaches that. As in that instance, I act as the board's lawyer, but the board will make the decision, and it's a case-by-case basis. I think in recent years, we've seen more and more courts disagreeing with the board and disagreeing with each other on specific issues. So it's become a little more complex for the board to figure out what they do in a particular case. In that case, of course, the board accepted the remand and revised its position on exemption for religious institutions. But there's no big procedural change. The procedure's basically set.
Thank you. Any other questions from the participants? If not, I have more. Well, here we go. Dorielle Paul.
Hello there. Can you hear me?
I can. You saved the audience for more of my questions, so congratulations.
I was waiting to see if it was needed or not. Usually I'm the pit diver. So, all right. This question is for Judge Gustafson. My question has to do with the potential conflict between state and federal findings when it comes to any sort of discrimination. Specifically, what way, if any, does a state's equal employment equivalent, whatever conclusion they reach, what way, if any, does it have if that employee was to appeal it federally as well? The reason I say this, and that with the question mark, but the reason I say this is if a worker was to be living in a jurisdiction, a state, that they brought a claim under the state's Human Rights Act, that would obviously have just some discriminatory element to it, but it's not as conservative in its leanings, and that board found against the worker. As I said, what if any weight does that prior state level finding have with respect to any sort of federal pursuit with the EEOC? And thank you.
The EEOC has work sharing agreements with the various state FEPAs, the Fair Employment Practice Agencies, and you'd really have to look in a particular state to see what the agreement was with that state in more detail. Certainly, it sounds to me like you would be running into issue res judicata or issue preclusion or something if you already tried the case under one law, and then you tried to bring it under, if you tried it under state law and then you tried to bring it under federal law, generally these things are brought together at the same time and they go forward in courts together. The Title VII cases can be heard by state courts as well as by the federal district courts. So it's just very difficult for me to picture that situation. If you had a situation where you had a state agency not paying attention to your claim and the statute of limitation hadn't run, there would be nothing that precluded you from bringing it to the EEOC, if that's what the question is, and having the EEOC look at it with new eyes. But generally speaking, the EEOC is deferring to the state agencies when there's a work sharing agreement, and we've decided you look at the case and then we'll go along with whatever you've decided about that. But the employee definitely has a right to choose which venue they want to come into, the State Fair Employment Practice Agency or the EEOC.
Thank you. Samuel McVeigh.
Okay. I wonder what involvement your agencies have had with the political advocacy and organization activities of the public employee unions.
I apologize. I didn't hear the end of the question.
Talking about public employee unions.
I'll
So,
tackle that one first. We have two unions, the National Labor Relations Board Union, NLRBU, and the Professional Association. The BU mostly does the field and some headquarters people. The PA is for the professionals at headquarters. We are negotiating contracts with both of those entities, as well as dealing with them on a variety of things that have come up, say COVID related, et cetera. I would say that's a very active situation in our dealing with them. They're not shy in putting forward what their position is. And when we came into this situation, the PA contract had not been renegotiated for 18 years. And the BU contract hadn't substantially changed in about 6 or 7. So there was definite need to take a look at some of the provisions and bargain. But we're in very active bargaining with both unions on a new contract on a variety of fronts. So we interact on a daily basis with our unions.
and I can tell you the Department of Labor, that is handled by another component within that handles shared service and more of a unified department-wide human resources unit, but they have also been involved with some negotiations and bargaining over the last few years. And again, I will say not only has that component been very supportive, has our HR component been very supportive of the wage and hour agency, but we've enjoyed a very productive and respectful relationship with we actually have 3 public sector unions within the agency of wage and hour. And so they've been very constructive and helpful for us in making sure as we make changes and move forward, we do so in a measured and appropriate way.
Here at the EEOC, I have very little interaction with the unions. I have had a little bit. It's been a fine, respectful relationship when it's come up with our own employees who have claims against the EEOC. But any negotiating of contracts and that sort of thing is not done here by the General Counsel's office, but rather by the Chair's office.
Well, I'm going to wrap up here, so we're on time. I want to thank our panelists for doing a fabulous job and our audience today for participating. And I just want to remind everyone that the next event is a discussion of intellectual property rights and the rule of law. It begins at 2 p.m. and I saw Professor Epstein was on that. So that's always interesting. No matter what you think of the subject, he will say something interesting. So it's worth zooming in and hearing that panel. So thank you all again. I remind you that your CLE password, last chance, is WCV12. Have a nice day, everyone.
Thank you.